Hello, everybody. Gentle lady, Hi, everyone. Come on in. Hello, everybody. Let me edit this real quick. 130. 234. 230. Hi, everyone. Come on in. Say hello. Come on in. Say hello. Hi, everybody. Hello, stay for real. Hey, Miss Joy. How are you? Ekale King Nase. There's a Nashe. King. Ekale. um, hello, Miss Amoni. How are you? I haven't seen you on live in a long time. You're just making all these dollars. Oh, gal. MRS deal. Hi, everybody. Hello, hello, hello. Hello, Rano72. Hello, Prince. Coming in. Hello, Facebook. Hello, YouTube. How's everyone doing? Okay, let's see. Banners. All right. Can everybody hear me good? I just had a flash on my, make sure I'm using the right internet. Okay. Yeah. Hi, PDE Solution. Thank you, King. I appreciate that. Hello, Rutman. I have a friend whose name goes by Ruckman. Ruckman. I love that name. Hello, C. Corride. Loud and clear. Thank you. All right. What about y'all on? I say y'all a lot. I'm way too long to get this out. What about you guys on YouTube and Facebook? Somebody, hello, Mr. Ernest. Where have you been? I haven't seen your live forever. Can you hear me good on YouTube? Because yeah, Red, your YouTube. Let me know if you can hear. I went out real like for a brief moment there, but I think I'm back. Would you let me know? Just say yes if you can. Come on in, come on in. Say hello, say hello. Hi, everyone. Hello, Tortevic 2. Coming in. And please start sharing this video. I would really, really appreciate that. Let's talk immigration. Let me see. Loud and clear. All right, perfect. Thank you. All right, everyone. This is Attorney Abisola Adebola Olale Samuel. Mobabasam. Immigration lawyer based in Alabama, representing immigration clients in all states. Well, maybe the only state I would not go would be Alaska. I don't know. Do people live in Alaska? Like, do immigrants live in Alaska? Trying to be politically correct. But anyway, if you've got an immigration case, if it's a case that we handle, it doesn't matter what state you live in. I go everywhere. If you pay me, I go. And if you don't pay me, I stay. Come on in, say hello. For your questions in the comment section, you guys already know the drill. If you need to contact our office, number is 334-341-4475. Website is olalayalawfirm.com. Send an email to AOS. That's my personal email address. I answer, and that's the only one who has access to that. I'm pretty good in answering emails unless I've been in court. Like today, I was in court. So if you haven't heard back from me, yeah, it's because I do current defense and family law. Said that I shut my phone down. I have to concentrate on what I'm doing. But email us aos@olalayalawfirm.com, info@olalayalawfirm.com. Once again, number is 334-341-4475. You can also text us to that number. And please share this video, like and share Facebook page, follow us on TikTok, Instagram, subscribe to YouTube channel. If you put in Olale Immigration on all platforms, this girl with the gray hair, salt and pepper hair, what could show up? But anyway, let's talk immigration. Let's talk immigration. This is something. Today's topic is very, very common, and yeah, I'll get to the questions later on. So this evening, I want to talk about what does it mean if you're coming into the country or you came into the country and at the port of entry, the CBP officer, Customs Border Patrol officer, stamps your passport and says no AOS, COS, EOS. If you have that stamp, I can tell you how many clients that I represent that came in and have that stamp on the passport, and it worries a lot of people. Like, okay, what does that even mean? So that's what we're going to talk about this evening. Let's address that. Thank you, I appreciate that. So when you come in as a non-immigrant, especially this happens mostly with tourist visas. So you come in, generally, you will be granted an authorized stay of 6 months. That's the general rule. Your I-94 will be good for 6 months. You don't get an I-94 when you come in on like when it used to be paper form. But when you come in, you can actually go online and pull your I-94 and know exactly what date you're given to leave up until what day you're given to leave the country. However, there are some situations where you come in, you get to the port of entry, the CBP officer has tons of questions, and then for whatever reason, they decide, okay, we're going to stamp your passport with no AOS, COS, EOS stamp in it. And then I get people calling like, okay, I've overstayed and I was given just 2 weeks. And, and usually when they say no EOS, EOS, COS, they would give you less than 6 months. And everyone is like, okay, what does that mean? Doesn't mean if I get married, I cannot adjust my status. Doesn't mean I cannot extend my status. So what do they actually stand for? AOS is adjustment of status. COS is change of status. EOS is extension of status. So whenever you have that stamp in your passport at the port of entry, basically the CBP officer is saying you cannot adjust status, you cannot change your status, and you cannot extend your status. That's basically what that means, long and short story. So the question then is, does it mean if I get married, say 6 months down the road, or I plan to go, but something, I just decided to stay back. 6 months down the road, I get married, my spouse wants to file initiate an alien relative petition on my behalf so I can file a green card. Does that mean that we're going to have issues? Or does that mean I cannot go ahead with that process? Short answer, no. So here's why. CBP, so we have Department of Homeland Security, all of them, CBP and the Department of Homeland Security and Department of State, different sub-departments or agencies fall under those two departments. Now, CBP is Customs and Border Patrol, right? They're at the port of entry. They decide whether or not to admit a non-citizen or foreign person into the United States. When they have suspicion of maybe somehow, because everyone who's coming in on a tourist visa, you are still you're required to still maintain that intention, the non-immigrant intention, up until when you are admitted throughout your stay and you're expected to leave. But once you come to the port of entry and for whatever reason, the CBP officer does not think that you will leave, or they feel like, okay, you're going to get in and you would want to adjust your status, that, hey, Miss Stanley, they put that in your passport. However, even though the CBP officer is saying no AOS, no COS, and no EOS, right? CBP officers do not have the authority to tell you that you cannot adjust. They do not have the authority to tell you that you cannot change your status. And they do not have the authority to tell you that you cannot extend your status, because that is a separate agency from the agency that actually tells you or gives you the authority to either extend, change, or adjust your status. That agency, that sole discretion lies with USCIS. USCIS is completely separate from CBP. So even though you have that stamp in your passport, it does not hold, it's not binding on you, because the only agency that can deny an adjustment of status, extension of status, or change of status is the United States Citizen and Immigration Services, USCIS. So that's that in a nutshell. And, your CBP officer has no right, no authority to deny you or to prevent you from adjusting status or changing status. However, this is where there is an exception to the rule in the legal field, as you already know. However, it holds water in the sense that it is a recommendation by the CBP officer, potentially to an immigration officer with the USCIS, that they are recommending. And, they would make notes. And sometimes if you do a FOIA request, sometimes they release it, sometimes they will redact that part. And whatever it is, they would make a recommendation to the USCIS office saying, basically it's a recommendation of, we don't think this person is going to leave. They had the intention. We believe they had the intention at the time of entry that they are not going to be leaving. So we're recommending that don't allow them to adjust their status. Don't allow them to change their status. Don't allow them to extend their status. USCIS officer, when you're now filing an extension, so can you still file your extension of status 539? Yes. Can you still file your 485? Yes. Can you still file your 539 to change status? Yes. However, USCIS officer can take into consideration the recommendation of the CBP officer, and they will want to find out why. But if the only thing that was the only basis for them putting that in stamping that in your passport is solely because they did not think you had the intention to leave, and you're married to a U.S. citizen, if you overstayed, because the law allows you to be exempt as an immediate relative from unlawful presence, inadmissibility for your green card application, there's nothing anyone can do about that. End of story. It may be a red flag. They may question you during the interview and say, hey, did you have the intention when you came in to not leave and all that? And your answer should always be no, because I'm not, 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕. I can't predict the future. I had plans to leave, but yeah, something preventing you from leaving. So that's that in a nutshell. AOS, COS, EOS. Can you still adjust? Can you change your status? Can't you extend your status in spite of having that stamped in your passport? Short answer, no, because really it goes towards unlawful presence. Now, if you have any other inadmissibility issues besides unlawful presence as an immediate relative or as a VASL petitioner, then that's completely different, right? But that's that in a nutshell. CBP officer cannot prevent you from adjusting or applying to adjust status, extend your status, or change your status, because that agency is not the agency that has the authority to decide whether or not you can do any of those three, submit any of those three applications. That's that in a nutshell, people. That's all she wrote. So, okay. So, because whenever I have consultations, I always know if someone has that issue, somebody else has it. And so I had one on Tuesday and then one today. I was like, okay, let me just touch on this real quick. And then it's going to be a short night. So it's Thursday. Okay, so let me go. I'm going to start on, hey, Miss Pam. You are absolutely welcome. As you're going. Okay. Akeem Owolabi. Loud and clear in New York. Yeah. Do y'all know that I'm actually licensed in New York? Yep. And that was what did it for me. The last studying I did was a New York bar. And I said, Jesus help me. Because I knock on wood, I used to say, and I used to tease my siblings that I'm the only one out of the four of us that's never had to sit for an exam twice. Y'all don't want to hear conversations with my siblings. It's like, But the New York bar is a different animal. I'm not licensed in Texas, but I can represent immigration clients in any state. And so that's a question I get every day. And the reason why I can represent any client, any immigration client in any state is because immigration is federal law. Immigration law is federal law. So that's federal practice. And so if something is just like bankruptcy, if you're licensed in, there's no national bar exam for in the United States, like in Nigeria, where I got my first law degree and bar license. Nigeria has a national exam, so you take your bar exam in any of the campuses, and you can practice in any state. United States is different. Every state has its own bar exam. Some states allow you to do reciprocity, in the sense of, if you're licensed and then after a certain time, then you can apply to become an attorney in another state, or vice versa, or you can file a motion. Those of us who have a foreign degree tend to see that not all states are receptive to that. So for instance, Mississippi would not let you sit for the bar exam, even though it's the same darn thing you did for 6-7 years back home. Alabama, where I currently have my physical office, require you to do a master's degree. So I had to go back to school to get an LLM degree in American Legal Studies, and then sat for the bar. New York, on the other hand, however, and some other states, but my dad, listen, probably the only reason I did the New York bar was because of my father. So, but New York bar, New York is New York. Oh my God, they're getting with what's going on in other countries. So as long as you have your evaluation done on your credentials or your transcript, and anyone who finished from Nigerian law school, they recognize that it is the equivalent of a 3-year law school degree in the United States. You have that done, and then they will let you know if you can approve you to sit for the bar. So basically, I didn't have to do anything additional for New York besides sitting for the bar exam, which is just, listen, I finished the exam. I was like, you know what? That's not how I'm ever going to pass that. Like, that was not even written in English. So when I got my result, it was like, I'll be damned. And that was it. I was like, I ain't doing no more exams. Can't do it. I cannot do any. Now I still have to do continuing legal education each year. But so I can represent you as an immigration client in any state. If you ever get an email from me, it's actually at the signature button of my email, and you can check that online. So it doesn't matter what state the attorney lives in. Okay. And disclaimer, all answers are just very, very basic in general. If you need anything specific to your case, that requires a proper paid consultation. What if you have, Alicia, what if you have a pending case and they send you an RFE and you're about to file for VAWA? What does that mean? What do you mean? What does that mean? You have an RFE, so you either respond to it or you ask them to switch your case to a VAWA case. Hola, Miguel. Okay. Hello, Mr. Sullivan. Greetings from California. Thank you all for joining. Appreciate that. Okay, let's go to Instagram. Let's see. Yes, gently. Thank you. You love the video. I don't look for trouble. I always mind my own business until USCIS decides to look for my trouble. Like this evening, I just got a notification. We just sent a family law adjustment of marriage-based adjustment status package last week. And I just got a notification that the request for initial evidence. I'm telling you, if they come back and they tell me the request for initial evidence is for, because one common thing that USCIS has been doing when it comes to marriage-based cases is sending frivolous, ridiculous RFP for I-864, even when it's already included in the package. If that's what they're sending to me, I'm telling you, That's why sometimes, like, I'm just minding my own business. They just want to trouble. They just want to, for no reason. No reason. Just mind your own business. But we'll see. Well, thank you. Solomon, okay, how can you help me get interview date for immigrant visa? You can always ask for, if you have a medical basis or some humanitarian grounds to expedite your case, then you can submit that. If you do not have that, you're going to have to wait. I don't care what any attorney tells you. That's just the way it is. And I know a lot, this is Nigerian. I know Nigerians are not the most patient people, but you're going to have to be patient. There's nothing you can do other than having proof of some urgent or and or humanitarian grounds to expedite your immigrant visa interview. That's just the truth. That's what it is. Okay. Let's see. Okay. So this is Bride Godson 123. I was issued my 10 years green card this year. What year can I apply for my citizenship? Once again, nothing specific to your case because I don't know anything about your case. But generally, if you are, if you're getting a green card for the first time, meaning you haven't had a conditional resident card in the past, then you're eligible for citizenship. An immigrant is eligible for citizenship after 3 years as a legal permanent resident, meaning after 3 years since you've been granted that card, and you are married to a citizen and you continue to be married to that citizen spouse. If you had a conditional residency card prior to your 10-year green card, then the time that you were a conditional resident counts towards that 3 years. If you're not filing your naturalization application based on marriage to a citizen, then you will have to wait 5 years. So you must have been a legal permanent resident for 5 years. If you are filing, if you got your 10-year green card based on a 751, you've had the conditional residency for 2 years, and then you got your 10-year green card based on a 751 abuse ground or abuse ground, that means that, and you're no longer married to that citizen, you are still eligible to file for your naturalization as long as you added 2 years and it makes up 3 years, whether or not you're still married to that citizen. If you are a 𝒊𝒎𝒎𝒊 petitioner, that means you've never had a green card at all. The very first green card you will get will be the 10-year green card. A 𝒊𝒎𝒎 petitioner does not get a conditional residency card, regardless of if your marriage was less than 2 years. So if you're granted you become a green card holder from being a 𝒊𝒎𝒎𝒊 petitioner, and your spouse, the abuser, is a citizen, then you are eligible to file for citizenship after 3 years after getting your green card. And it's a mouthful, but that's how it is. Okay. Global CEO. Yes, I'm not licensed in Texas, but if you're asking because wanting to see if I can represent you in your immigration case, nothing else, just immigration, then it doesn't matter what state. But I'm not licensed in Texas and I'm not licensed in Illinois either. Hello, Fully Lawal. You're welcome. That answers your question. Perfect. So y'all tell me what you think about this. I haven't started anything, but because of, good evening, Miss Chrissy, how are you? Lady B, please can I file for divorce when my bat is on and my husband is in jail for domestic violence against me? I can't speak to your specific case, but generally, if you have a valid case, you are able to divorce. But I always say if you do not have to file get a divorce, just do an informal separation. You can move on with your life. Reason being, I have cases I'm working on that they either filed for them by themselves or for whatever reason was denied, and that can take anywhere from 18 months to 3 years. So you're only eligible to file for VA subsequent to a divorce within 2 years from the final judgment order. So if you're looking at a case that may take 3 years and you have to start all over again, then you're going to be out of luck. But if you're separated but still legally married, you're able to restart the case. So, but if you feel, you know what, no, I just can't, I just got a divorce, then yeah, generally there is nothing that says you cannot divorce your spouse, your abuser, once before or after you file for vow. Okay. Oh, I was saying, so I'm thinking, y'all can let me know what you think. I'm thinking because I know that a lot of people like, she's a loyal gal, what in charge of constitution, but it's not. You can't see a doctor for free. You don't even know if the doctor can help your case, but they will tell you to pay for the office visit before you even see the doctor. It's the same thing. But there are. Is there anything I can do if the interview has been 4 months ago without getting back to me? I think you already sent me a message about that. You can contact them and see what's going on. Call USCIS and see if they have any update for you. There may be something that happened because I don't have any. I have many more of my clients now. Once we are done with the citizenship, many field offices actually have same day oath ceremonies. So, but you can call USCIS. So, hey, Ms. Ayola, how are you? I'm thinking to do, and I'm going to try one time and then we'll see how it goes. To do like a Zoom class where it will be like maybe a $50 charge for each person. Now, it's not going to be one-on-one. It's going to be a whole Zoom conference. But everyone gets to have 5 questions answered. And you're going to have to sign consent that you already know that it doesn't create an attorney-client relationship. But like $50 each person, but we'll have, most likely on a Saturday where a lot of people are, most people work during the week. And you can answer, you get a chance to have 5 questions answered, but everyone is going to be listening. But it will only be for those who have paid and will directly have that Zoom link. And then we can do something like that and see how that goes, because we're trying to add some things to the website, but I want to test some things out and see how. So y'all tell me what you think. Y'all tell me what you think about that. Because obviously $50 is a whole lot cheaper than consultation time for 30 minutes. Good idea. Okay. But you get 5 questions answered as detailed as possible given the time frame. I would not review any documents. So if you have reviewed documents, then no. But that gives you a chance to just ask the questions you want answered and make sure that it will be answered. And then we'll see how that goes. What y'all think on Instagram? I see. Okay, I'm getting yes from Facebook and YouTube. All right, good. Okay. Okay, so I'm seeing that people. All right, I don't like giving up my Saturdays because that's when I have to like okay. But I think it's because a lot of people say, "Hey, yeah, okay, yes, that would be great." Okay, I will post it. I haven't finalized anything. I was just thinking. Listen, Y'all need to live in my brain for one day. You'll be very scared. Like you're like, that's why she doesn't sleep. Yeah. But I just feel it's gonna be, thank you, TLC. I think that will be really good. Is it advisable to travel with advanced further documents? As long as you have no other issues outside of a lawful presence overstay, there is no issues generally. That doesn't have, that's not to your case, just that's general. Yes, I see. Okay, so we'll do it. I'll put that in. Add you to the Zoom. Okay. I don't know what time. I'm just gonna put it out there and see. Um, and we will, if you're interested, we'll have a link. Okay, what you can click on. But then I'm trying to see where. Well, we'll have names, and then you have to write your name, and then you have to send in your questions beforehand, so we make it real fast. Um, Gary Fish, is it okay to reach out to USCIs despite the new processing time? The new processing time, there's a way where you put in your priority date, and if your priority date still says, it will tell you the earliest date that you can contact them. If you contact them earlier than your date, then um, it, it doesn't. It's the same thing you're going to be told on the phone. Is the same thing your lawyer is going to be told on the phone. If your case is still within normal presence, unless you have basis to expedite your case. Africans are the most impatient people. I raise both hands because I always say that the day Jesus was given patience in heaven before he sent me down to earth, I was not present. And he just said, hey, wow, that's all. I am an instant gratification kind of person. So I get it. But I have come to learn in this work that I do that I've got to make sure that I sit my down and just be patient. I got someone who emailed me like I filed my I-130 for my spouse on April, I think it was April 27, but it hasn't been approved. And I'm thinking, do you mean April 27 last year? And he says, no, this year. Yeah. $49.99. I love that. $9, and I love your name too. This is, I appreciate you. Thanks for all. Learn so much from you and telling others along the way. Thank you. I appreciate that. You're so good at what you do. Thank you. I really do appreciate that. My 11-year-old, I'm going to put you on the screen. Does she want to be a lawyer? My 11-year-old daughter walked in and said, Mom, wow, she's pretty. It's the makeup. I think so. Hotel has said thank you. Is it normal to wait almost 8 months to get a green card after the initial interview? If that basically means your case is under further review. There's a whole lot of reasons why it can be. If a marriage was voided and interview later came. Now, so there is, I'm going to look it up. I'm trying to thank you, Miss Chrissy. But there is a policy that was released that USCIs cannot deny a petition solely on the basis of the fact that a marriage was annulled if it happens after the petition was filed. And that applies mainly, it usually applies to vow petitions and all, but your case is one that you will want to sit down, or if we put this, what's everybody's schedule like this Saturday night? Where's my phone? Oh, I'm using my phone because my baby has soccer tournament. When is his man? We'll be done. What's everybody's schedule this Saturday night? Let's just even do it, Braun, and see how it goes. The any signatures. Can you do? You're not doing it on behalf of your lawyer. She says my EAD renewal priority date shows I can't start calling them from July 20 if I did not receive it. Can I do it on behalf of my lawyer? You're not doing anything on behalf of your lawyer. Your lawyer represents you. You're doing it on behalf of yourself. You're the applicant, so nothing stops you from making the inquiry. But for me, most of the time, my clients will call me and say, "Hey, can we call USCIS?" And I try to make time so we can call USCIS and, um, you know, get that done, and they'll let us know, "Hey, okay, yeah, we'll a tier 2 officer will call you or something." So, but I think we'll do a test run and see how that goes. Whenever I do concessions on weekends, it's more because I'm giving them my time. But I usually, like I always say, I'm a full-time mother, and in my spare time I practice law because my kids come first. Like, it's God and then my kids. That's the order. So the baby has soccer tournament this weekend, but I'll see. I will put it on all platforms, and then we'll see if we get up to 10, then it will hold. If I get less than 10, I will probably just refund your money because it's not worth for me. Hello, Mr. Sunji, how are you? I haven't seen you forever. Mom C triple. What's the time frame for a? Do you mean deceased spouse can put in filing papers? You have to file within 2 years from the person's death, generally. What is required to expedite a case? It depends on what kind of case you're trying to expedite. Okay. How long does it take to get a work permit after application through VAWA, or what are the processes for documents to be received? The very first question you have to ask yourself is the work permit. Did you file a work permit with your petition? If you did file a work permit, was it based on your green card, or are you filing a C-31? That's what's going to determine how soon you're going to get your work permit. I got 3 work permits today. Time frame for, so let's see, one was filed July last year, and we just got it almost a year, 10 months, 10 and a half months. One was filed in December 2021. And the last one that came in today was filed January 3rd this year. All 3 cases are VAWA based, but you can see the discrepancy. There's no rhyme or reason to it. So I recently sent the form of ombudsman to DHS to help me on my pending cases. How many weeks should I wait for USCIS response? So you mean ombudsman, you made an ombudsman inquiry to help you contact them. They will, so the whole point of ombudsman inquiry is so they can contact USCIS on your behalf, and then they will email you back and let you know what they found out. So you would have to wait for them to contact you. Y'all need to exercise some patience. Come on, people. You've got to exercise patience, because I've seen cases where, and I'll give you a prime example. Nobody knows everything. I don't know I wish I did. But I thank God I don't know everything, because given my kind of personality, it wouldn't be good if I knew everything. But you've got to be patient, because when you are rushing, you may actually hurt your case more than help your case. Example, case in point. There's a guy that contacted me, and he wanted me to respond to a notice of intent to deny for them. And I go, I have got a very busy practice. So we usually require 45, 60 days, especially for VAWA cases. I've got a lot of cases, and it's important to dedicate the same amount of energy and commitment to everybody's case. And I always say the longest part of getting case out is when it gets to my desk. My girls are super fast, and they will be in contact with you to get information. But because I've got to review I had a lady that we were going to send her case out. I'm extremely diligent. Do I miss things or I make errors? Yes. But I've got to make sure that what I'm sending out isn't going to hurt you. And she was so much in a hurry, and we're now at the point where she says, You have no idea how much you mean to me. And here's why. I was reviewing her file, and it turns out because she's divorced from her husband, from the abuser, and I'm going to, because I have a checklist that I use for myself. And, I go to the divorce, the marriage proof of qualifying relationship part. And I go, okay, so she's divorced. What is the final date of divorce? So it's within the time frame. And then I noticed that the final order of divorce wasn't actually a divorce. It was an annulment of the marriage. The difference between a divorce and an annulment is a divorce terminates a previously existing marriage. An annulment terminates the relationship and puts you back where you started, as if that marriage never existed. So if you have an annulment prior to filing a marriage or vow-based petition, then that means you never had a valid marriage, and that means you don't have a qualifying relationship. And so I called her. I was like, "Hey, Miss," her first initial is C, Miss C. Do you understand that you actually got your marriage annulled and not divorced? And she goes, "No, no, no. I found." And then we went through. She goes, "Well, oh, I did it myself." And I asked them at the court, like, what do I need to find? That they just gave me these papers, and I go. She goes, "Is it bad?" Like, yeah, it's bad, because it means everything we've been working on, it doesn't. Long story short, luckily I was able to put her in contact with, because it's not in the state of Alabama. Luckily, I was able to get her in contact with a lawyer that practices family law in her state. And luckily for us, they will be able to file a motion with the court to set aside that annulment, and then she'll be back as married, and we can proceed and submit her petition. So if we were so much in a rush and we send it out, like, okay, then we would get an RFE from the one service center saying, where's the proof of marriage? Because what we have is the relationship was annulled. So there was no annulment, makes everything void. Basically, in a nutshell, it never happened. So and one of the requirements of a vow petition is you must have a qualifying relationship. Either you're married to the person, still married, you were married to the person, but the person committed bigamy, meaning your marriage was never valid, but you did not know, or you're divorced and you filed within 2 years from the divorce. Annulment is marriage never existed. And so, exactly. And so I'm telling you, she was silent and started crying on the phone. And I go, when I tell my clients, I got you, because I make errors. We're human. But I try the best, and I tell people, please don't rush me. We're giving you this time frame for a reason, because I've got to see every single document. I have to read your declaration and make sure that your declaration meshes with the evaluation report. If there's a discrepancy, we have to fix that before we send it, because they're looking at every single thing, And so right now, thankfully, we're waiting on the annulment to be set aside. We'll get a new, once we have that order in place, so she's back to be married, then we will have to redo the forms and take away everything about divorce date and all that. So y'all need to exercise patience. The other guy I was talking about, he wanted me to respond to her notice of intent, and I told him this is the time frame we're working on. I cannot get it out before this day, because I'm not going to. I have some cases that are emergency, like we've got to do it. Like if you get denied a 751, for instance, because there's no appeal for a 751, for the most part, half of the time, USCIS will send you an NTH appeal in immigration court. If I get someone that a 751 was denied and there is no notice to appear that's been issued, I always file the I-751 again within 2 weeks. because once you file it, they cannot send your notice to appear until that has been, and that was sent in these supporting documents later on. But if it's not emergent, I would say just be patient. So this guy said, I can't do that. The good thing is we have additional 60 days. So 90 days total to be able to sit down, respond, and make sure we respond, well. He says, okay. So he went ahead and he retained my services, came back and said, you know what? I can't wait. Can you refund my money? Like, okay, no problem. Listen, we usually charge them because once you retain me, we're opening files and already there's a whole lot that goes on within the first 48 hours. And that's time. But I just didn't even try, just give him everything back. Didn't hear from him for about 3-4 weeks. And then last week I heard back from him saying, please, I need your help. What did he do? He wasn't patient. And so rather than sit down to respond to his notice of intent to deny and analyze every single, because for instance, I never sent a notice of intent to deny without a cover brief, really addressing every single point USCIS makes. He just sent in stuff and they came back last week and denied his case. And now he wants to ask to reopen because he didn't have an attorney help him. And I'm like, no, and that's when I tell you, I'm sorry, I cannot take your case. Patience. Patience I'm preaching to myself. I am not a patient human being. Everybody who knows me, my mama knows that. I want something done. Chris always tells me I'm the yets, that the yets enjoy means right now. That's me. But also, I know there's sometimes I just have to just take a step back and say, okay, I've got to learn how to be patient in this situation. But anyway, so I will put that up. Can I call for my son EAD, which is which I filed for with? So you filed for an EAD for your son. I can't say yes or no because I don't know anything about your case. You may be one of those who wants to use Zoom. So I'm going to put it up and I'll see how many people sign up. If it's up to 10, then okay, well, that's a go. If it's less than 10, I'm going to refund everybody's money because it's not going to be worth my time. That's just the truth. Yeah, but okay, everyone. Let me see if there was any new question on Instagram. All right, nobody. Okay. All right. Okay, I already answered that. So I may or may not see you guys Saturday, whoever wants to join in. Is it possible to bring in a child while waiting for your vow to be approved? I mean, if your child applies for visitor visa and they come in, yeah, but you're not able to file anything on behalf of your child because you don't have a status to file anything for someone while you have a pending case. But anyway, once again, if we can help you with your immigration case, if you're on Facebook or YouTube, the information is right there on your screen. 334-341-4475, olalalawfirm.com. And go ahead and subscribe to the YouTube channel. I would really, really appreciate that. And I will see you guys. Keep in mind, we are not going to ever lose faith. We're always going to be hopeful. Bible says Abraham hoped against hope. So even when it doesn't make sense for you to keep hoping, if God gives you breath, gives you a new day, that's the reason to keep going, keep believing that, yes, it is possible. Miss Amomi is here, and she's my client. She's not signing on the movie, so you will know who it is. But I remember when we met back in Atlanta in February, when I looked at her case and I go, looking at it from a human perspective, it's a long shot. But I said we're going to agree in faith because there is nothing God cannot do and there's no mind he cannot change. And not only was her case denied, and then she filed because they said she didn't respond to her request for evidence, and they denied it. And then she appealed, and they denied it, and then she appealed again with her lawyer. Then, and I was like, it's a long shot. But I said we're going to agree in faith because there's nothing that is impossible with God. And when I tell you that, there's some cases that I keep Even though you haven't retained my service, I just get interested because I'm crazy like that. And so I was actually the one who told her, like, do you understand that they have reopened your case? They reopened her case, and what she was expecting was to get a request for evidence, the request to be given the chance to actually respond to the request for evidence. The next thing she got, or I should say, the notification I got on her behalf, is that they approved the VAL petition. Now, keep in mind, this is a woman who went last year from, we've denied your case because you failed to respond to a request for evidence that we sent you, denied twice, denied, and the appeal denied, so two denials. Went from that to God saying, y'all have spoken as humans, but now I'm going to step in. And not only did they reopen her case, she didn't have to deal with her RFE. The next thing that came was an approval. Keep believing. That's all that is to say, to keep believing. There is nothing impossible with God. As sure as I am that my name is 𝒊𝒎𝒎𝒊𝒈𝒓𝒂𝒏𝒕, that I know that my dad was my father. My mother, I don't know. But that's how certain I am that there is nothing, there is nothing God cannot do. All right, everybody. Thank you for joining me. Bye-bye.